are you saying that the minister has got no jurisdiction in terms of ensuring that transformation through these amendments is being achieved in the country in terms of the private sector? Everything must be left to the private sector for the private sector to do as they wish. The minister, which government through the Minister of Employment and Labor, has got no jurisdiction to do. Can you clarify more for me to understand whether that is what you are saying, in particular about the role of government in ensuring that there is transformation in this country because of the past that we are coming from, which is something that we can't run away from it. If we are to correct, there are things that we are to look into. And you are saying something very, very important, that it's you welcome these questions. We are in a question session for now. We are still going to have our own discussion as they, but we are in a question session now to you people who have seen it important that they must be part of the of these processes by Parliament. That will be my last just question of clarity from you in terms of what is your understanding and what do you think that the minister the government must do in addressing the imbalances of the past, which are more than 3 decades. We can't run away from that. Thank you very much, sir.
Thank you, Chair. I see that Honourable Member Mkontu also has a hand up, but if I may, Chairperson, I'm just going to answer that question. If there's possibly a follow-up question from her side.
Leave the hands to me. I see that it was an old hand. Okay.
Okay. Chairperson, in relation to your question, I will never dispute that there is inequality in South Africa. That's a given fact. Although I might argue, if you look at the recent report by Stats SA, it seems that equality has shifted from between races, that there's more inequality in today's society in race, in a specific race group, as there was between race groups. So I think there's a shift of inequality. But to answer your question, Chair, I think there is a role to play by the Department of Labour and by the Minister. But yet again, I have to reiterate that role is to ensure that there's a good opportunities, or let's say equal rights to opportunities, for her to ensure that everyone has the right to opportunity at the end of the day. And that's a quite an honourable task which is placed on the Minister. It's up to her to ensure that every employee has the necessary tools to ensure to compete on the same footing as everyone else. So whilst the current focus, it seems to be on the equality in outcome, we propose that there must be a shift to equality in opportunity. We say that there must be a shift from looking at race as a proxy for affirmative action. There must be a shift to socioeconomic needs as a proxy for affirmative action. If there is a focus to equality in opportunity and you look at socioeconomic needs as a proxy, then most certainly, Chairperson, we argue that the inequality to a certain extent will be dealt with, and I don't think in our lifetime, but there is a possibility that it would be eradicated.
No, thank you very much. Can I just check, is there any member who wants to, before we release Mr. Anthony? The only thing is that which you didn't respond to. You didn't respond to the question that I asked. Didn't you think that it would have been better for you to have a more pointed examples so that we don't then become general? More pointed examples so that as we will be engaged on our deliberations, because we are going to do that but don't you think that it would have been much better if you had a pointed? I'm raising this because we have passed now the era of being general at all, because we want to correct a particular a situation and environment in the country, and therefore it will be important for lawmakers and people in private and in business and communities like yourselves and also ourselves to be pointed, so that's why, so that we know that we don't then again have to come back and say, but where is that place, by the way? That's why for me as the chair, I think to make things easier and more swift, not swift exactly, more being able for us to engage without any tensions, any suspicions, is that we are then pointed, given the information by you people. If you have done that in your written submission, we'll then have to go back to that. If you haven't, can you respond? Do you think that it's a fair question and a fair exercise that the chair of the committee is asking?
Chairperson, in our inputs, we haven't as such looked or alluded to certain specific examples. We can do that if we still have the opportunity to do that. In our view of this process was a more generalized legal argument as to whether it complies with international and national standards. So my apologies for that. We didn't look into depth into specific cases. What I can argue, or what I can say to you today, is we have been busy in courts with a few specific matters wherein employers has gone outside the framework as stated by the Employment Equity Act. And one specific example that I can give you is the Department of Correctional Services. It was a constitutional matter which we dealt with about 3 or 4 or 5 years ago, and there it was clearly stated by the court that the framework as set by the Employment Equity Act, and this, I say this specifically because we are currently dealing with the aspect wherein the framework of the Employment Equity Act is being broadened to make provision for the department and for the minister to have quite a crucial input in the process. So I'm giving the specific example. In that court case, the DCS, the Department of Correctional court case, the court was quite clear that you have the framework as set by the Employment Equity Act must be is quite strict, and it dealt in that specific matter with the regionally active population that must be taken into account. So the court was quite clear that you need to take national and regional economic, the regional and national economic active population into account. We say that the proposal made by the minister to untrammeled or to unfettered make a sectoral determination without looking into specifically the nuances of the region and the context of a company in that specific region will not comply with the Constitutional Court's judgment in that specific matter.
No, thank you very much, Mr. Anthony. We will appreciate. You can. You are welcome to stay and be part of the entire day's proceedings. It's all up to you. But thank you very much for availing yourself and for showing interest in the process that we're engaged in. Thank you very much.
Chair, from my side, thanks a lot. Thanks to all the honourable members, for giving me the opportunity, and good luck. I think you have an extremely important job at hand, and good luck with that. I will ask to be excused. I have other commitments that I must attend to. So, but thanks a lot for the opportunity.
No, thank you very much. Thank you very much, sir. Honorable, I'm sorry, Mr. Sakaza, who is then the next?
Chair, it's gonna be now Summit. Miss Tanya Vogt has joined. I've made her co-host so that if she wants to share any presentation on the screen, she can do so. Tanya Vogt. Tanya. So Summit.
No, thank you very much. Over to you, ma'am.
Thank you so much, Honourable Chair and Honourable Members. Can I just confirm that you can see my presentation?
Yes, yes, we can see it on my side. I don't know with other members, but if I can see it, I think everybody can see it. But we also want to see your face.
Beg your pardon. Let me just go back to. Just give me a second. I'm just trying to show. Go. There we go. Can you see me?
Yes, we can see you.
Great.
All right.
And you can see the presentation still?
Yes, yes. I don't have any indication from any members that they can't see it. So silence means everything is fine. You can continue, ma'am.
Thank you. All right, what we will cover in our session this morning is I will introduce the SAMET team, and please, if we could just give my SAMET team the opportunity to speak when we get there. We will also give you some background to the South African Medical Technology Industry Association, who we are, who we represent, and what our mission and vision is. And then we will go into our comment on the amendment bill. We will specifically look at the setting of sectors and subsectors, setting of targets, the employer's own targets, compliance with those targets, and other aspects of the amendment bill. So if I can go first into the team. I am Tanya Vogt. I'm the Executive Officer of the South African Medical Technology Industry Association, and very happy to be here. So thank you for the opportunity. And if I can hand over now to my team members, Matse Masilo, to introduce herself. If we can just allow Matse to be unmuted.
Hi, everyone. This is Mutse Masilo. I am the Transformation Chairperson of Summit. Thank you.
Thank you. And then Marlon Burgess. Marlon, are you there? Okay, hopefully Marlon will still join us if he's not there. Okay, so what I will cover is who we are. We are a not-for-gain industry association. We are a voluntary association, so it's not mandatory that our members belong to the association. We have been around for some time, since 1985, and have grown quite significantly in that time. So currently we have in excess of 200 member companies, and our membership is primarily companies that either import, export, distribute, wholesale, and also locally manufacture medical devices, and in vitro diagnostics. And I just want to spend a little bit of time on what a medical device or an in vitro diagnostic is, because I think it's important and is one of the foundations of our submission. This is a very complex and varied sector. So a medical device could be anything from a bandage, a drape, a mask, which could be considered under the definition of textiles. It could be implants, which could be of a metal nature or ceramic or other. It includes large capital equipment. It could be sutures. It could also be laboratory test kits. So a very large variety and range of products makes up what we term medical technologies. In fact, we have approximately 500,000 different medical technologies in South Africa at the moment. And just to be aware that the majority of the companies in our sector are actually small to medium distributors. So we are quite different to that of the pharmaceutical sector. Sometimes we get lumped with the pharmaceutical sector, but really we are very different in terms of our product profile, in terms of the quality management systems, and even the sort of general manufacturing practices, and also the regulatory requirements and the types of skills that are required for our sector. We also have 2 association members, the Medical Device Manufacturers of South Africa and the South African Laboratory and Diagnostics Association. And we have some associate members. These are companies that are generally service providers to the sector. They might be consultants, logistics companies, some trade promotion agencies even. We like to think of ourselves as the voice of the South African medtech and in vitro diagnostics industry. We really wish to increase the visibility of our sector, the understanding of our sector, and the diversity thereof. We advocate to inform healthcare policy and improve delivery of healthcare and access for patients to medical technologies. We share latest market trends. We promote industry best practices. And to that, in that regard, we have a code of ethical marketing and business practice that has been developed specifically with our sector in mind, and that all our members have to comply with. We provide networking opportunities, and we work with international best practice and organizations for global harmonization. We're also a member of some South African entities. They're listed on the slide. I won't go through them, and some international organizations. Our vision is to enable a sustainable, ethical, and transformed medtech industry that enhances patient access to quality technologies and innovative solutions. And we aim to provide our sector with a collective, objective, and credible platform for engaging with all stakeholders, private and public. And we hold transformation very dear to our hearts. As mentioned, Matse is the chairperson of our Transformation Committee. The board of SAMED, who are responsible for policy and identifying the strategic imperatives of SAMED, have for many years regarded transformation as important. It's an economic and social imperative. We acknowledge that our sector perhaps is not as transformed as it should be. And we also acknowledge that much has to be done to drive meaningful and sustainable change in our sector and in our country. So we fully support aspects of the Employment Equity Bill and policies thereon, and we strive to create an ecosystem that gives our members the tools in order to enable them to transform their companies. So we have submitted written comments, but we also requested this opportunity to make verbal representation, and so we appreciate that we've been afforded that opportunity. There are absolutely aspects of the bill that we fully support, and we've listed these in summary, particularly Section 1 in terms of people with disabilities, the definition being amended to include intellectual sensory impairment. Section 8 in terms of various elements that are required to be adhered to before psychological assessment is done. Section 37, which allows for an inspector to instruct an employer to prepare an employment equity plan, and on designated employers in terms of the thresholds per sector being repealed and only employers with more than 50 employees having to comply. There are some areas, however, that we have given due consideration to, and we would like the committee to be aware of these, please. So in terms of the standard industrial classification levels, we would like these to be more refined to ensure that similar employers in the medtech sector face similar regulatory and other requirements, because we feel that this will influence the pools of available candidates and also whether skills can be acquired or not at a new workplace, some of which are due to regulatory requirements. Our sector is regulated by the Medicines Act and the medical device regulations, and there are certain skills and requirements that are regulated in terms of the regulations. So what we have noted is that the SIC is at times inconsistent and not always aligned with medtech companies' employment equity report classifications. And it's really primarily because of this big diversity in the sector. So what we are asking is that sub-targets would need to be set up per division, and also that those sub-targets relate to the medtech industry specifically because of this vast diversity. As mentioned, some of our members fall within manufacturing of textiles, some within chemical products, some within pharmaceuticals, because there are products that have both a pharmaceutical component as well as a medical device component. We call these combination medical devices. As mentioned, there are test kits that would fall under plastics, rubber gloves, for example, capital equipment, and even other. So we therefore may fall under various categories and may be required to meet vastly different targets. And this is where this inconsistency or confusion or potential complexity lies or will arise. So we even find that medtech companies may fall within the retail space. And we also have, as I mentioned, companies that are considered wholesalers. So our proposal in this regard is that we would like to request that there is provision of more than 30 days to engage on any targets that are required, that a methodology be arrived at as to how the targets will be set and that be published potentially for comment. And also that the minister please consult with the relevant sector, i.e. the medtech sector, so that we can make sure that the SIC groups align, and that if agreement cannot be reached, that there is some form of arbitration. And these refer specifically to sections 15A subsection 3 and section 15A 5. I'm now going to hand over, if I may, to my colleague Motse.
Thank you, Tanya. Can you just go back to the last, the slide before, the one that you did? So I think there was a little bit of Tanya, slide 9. Go to
slide. Yeah. Sorry, I can't see. There we go. Yes, that one.
Yeah. Go to the next one. Yes, that one. So I think there was a little bit of confusion when Tanya presented this slide, because this slide is actually our proposal number 2. So apologies for that. So this is a summary of our proposal number 2, which we are saying that we would like the minister to consider for engagement to be more than 30 days, the methodology on how target assets to be published, and also to look at the different sectors that Tanya has alluded to. Next slide, please. So in the next slide, I will go into the details with regards to the setting of targets. So with regards to the setting of targets, we are saying that we would like the portfolio committee to consider that the legislation should allow for a consultative approach for setting this target. And what we mean by that is that it should be consultation with the sector, because as Tanya has alluded, that the sector is quite different. We've got multinationals, we've got wholesalers, we've got distributors. So for us to have a smooth process of what are the targets and looking at different companies, their sizes, their economy, it would be much easier if we come up with the targets that are being consulted with rather than targets that we are not sure where they're coming from. So it is just really a request to say, let's work together on coming up with these targets. I have already alluded to that the reason we would like to have that is because there are significant differences between the medical tech companies, and that's why we're saying let us have a consultative process on how we come in with these targets. We are of the view that a one-size-fits-all will not work, and we would not like to have targets that are either set too high and they're not achievable, or targets that are set too low and they're easy to achieve. And that's why we're saying, let's work together, the government and the industry, to come up with these targets. So that is really our proposal in terms of setting of targets. And next slide, please, Tanya. In terms of our proposal number 3, we would like to look at the practicalities of timing when we're setting these targets, and also we would like to look at the levels of compliance as set out in the law, in the Act. So let me talk to those a little bit and give some input on that. Next slide, please, Tanya. So in terms of the setting of targets, we're saying there is some wording that we are uncertain about, and we hope that we will get clarity, because as it is written now, we are not sure what it means. So in terms of the Employment Equity Act, how it works currently is that you need to achieve target every year. So it is an annual target. So with regards to this act or this amendment, we're seeking clarity to say, are we going to have multiple targets for subsequent year, or are we going to remain with this a one target on an annual basis? Because at the moment, what the Act is saying is that when you look at the employment equity, you look at it in 1 year, but you could have a plan for 3 years. So you could say, in the next 3 years, this is how I'm planning to transform my company. So is this amendment looking at the 2 or 3 years period, or is it only looking at 1 year? We are also saying that in terms of the method of issuing a compliance certificate, we're saying that we would like that methodology to be clarified on how companies will get this certificate. For example, if a company has been compliant, let's say on the management level, and it's not compliant on the other level of the different levels in the company, will they get a certificate when they are compliant with everything, or is it also part compliance will be looked at? And also, is it compliance over several years, which we think is actually the most sufficient way to do it, which is sustainable. If we say to a company, over a certain period of years, this is your compliance level and this is how it should be, rather than if we do it on an annual basis, then it is easy for companies to change and really, to have the people, but not over a long period of time. So what we are saying is that we need clarity on the issuing of the certificate, whether it's going to be on an annual basis or it's going to be over a period of time. So those are the clarities that we would like to have. And next slide, please, Tanya. Our fourth proposal is with regards to the process of compliance, of the compliance certificates and the challenges that we foresee in issuing these certificates. So let me talk to those slides in a detail. Next slide, Tanya. So what we're saying is that at the moment, the employer, according to the Employment Equity Act, the employer is setting their own targets, and they set those targets in consultation with the Employment Equity Forum, right? Now, with the sectoral targets, we want to clarify if does that fall away, meaning the employer is not going to set their own targets anymore, and they're not going to consult their EE forum anymore? Is the sectoral targets going to take precedence, or which one is going to be working? So it is just really for us to have clarity to say this amendment will also need to look at what the current Employment Equity Act is saying. And I have already spoken to the second point, which is in terms of the Employment Equity Act, designated employers are legally required to consult with the employees. So now with this amendment, would that still stay on, or will it change? Next slide, please, Tanya. Now, when it comes to compliance with the targets, it seems possible to justify non-compliance, which suppose a draft process where the employer could provide a justification why they are not compliant. So we would like to understand how will this process work, given the need for a compliance certificate, and when an employer has to tender for something, whether this is not going to delay the process, if then they will have to go back and saying, this is my justification why I'm not compliant. This is what happened. I've just retrenched people or whatever. So with the thinking in mind that the tenders have a time limit, is this process not going to be delayed? The timeline and the process of applying for a certificate are not stipulated in the current amendment. And our suggestion is that they should be stipulated so as the employers are also aware to say this is how long it will take before the certificate is issued. And we think that this is, a burden to the minister, and maybe it's not. But this is just us saying, we just don't see how it will work, and if it will work sufficiently, that's great, but we just saying that if it doesn't, then it could have a delay on other processes such as the tender process. Yes, okay, so I think yes, that's what I wanted to mainly cover on this slide. Next slide, please, Tanya. So in summary, and the next slide, As Summit, what we're saying is that we regard transformation as the economic and social imperative, and we are committed to it. And we think we really support it. It should be an ongoing process, and we actually support the amendments that have been tabled down. We're just thinking that some of the things maybe could be streamlined differently. We would like the committee to consider a more refined classifications, as Tanya has alluded to, and we would like the minister to consult with the relevant sectors, as I have spoken, what are the reasons for that. We think 30 days might be a bit too short in terms of engagement with the targets and the publications of the methodology of how these targets were set. So we are asking the committee to look at a little bit more time than 30 days. We have spoken to the practicality of how this will talk to other parts of the Employment Equity Act, which are already in law. And we have spoken also about the levels of compliance that should be set out in the Act. And lastly, we would please like the committee to look at the process of issuing the compliance certificates and the challenges that could be faced thereon. And if the committee would like to get in touch with us, I think it's very clear. Next slide, Tanya. You've got the numbers to the Summit office, the Transformation Committee email, and definitely you could contact us via Tanya. And that is all from us. Thank you very much for the opportunity, and we will take questions. Thank you.
Thank you very much. Ma'am. Just the latter, that's why when an invitation was sent to you requesting to come and make a oral presentation, it's how then we are getting in touch with you, so that we are then able to really do get the feel of what are your views, and they will then ask questions of clarity. Because now we're not engaging with you, we just want some clarities from yourself, so that when we engage the process, as the process unfolds, the committee will then sit and look and guided by the roles of Parliament on then what we should do. But I just want to, in listening to your presentation, maybe I will allow members to first, before I make my comment. Members, there is the presentation. Any questions, clarity on this presentation of Summit? Can I get an indication? Are there any hands? Now there is something on my screen. I can't then see. Can I be assisted by people that are technologically empowered? Because I want to see hands. I can't see hands. Tanya,
my hand is up.
Yeah, because Tanya's presentation is still on my screen.
Honorable Mkondo, Chair, and Honorable Kadwa, hands are up.
Okay, Honorable Mkondo. Okay, Honorable Mkondo, Honorable Kado. Okay, Honorable Mkondo.
Thanks, Chair. We welcome the presentation. My first question will be on the fact that The presenter, Ms. Tanya, said the sector is regulated. Can we be given details on as to what are the examples of the regulations that might not be in line with the bill? The second one, Ms. Muetsi said, the employer must set his or her own targets. And my question is, what about the standards? How is that going to be monitored? What standards is the employers, if given an opportunity to set their own targets, what are the standards that they are going to be monitored against? Thanks, Chair.
Thank you, Honorable Kado.
Thanks, Chair. I'm just unmuting myself. Thank you for the presentation, and I did read the written submission which is published on your website. My questions for clarification are these. Perhaps you could clarify for us what exactly are the main inconsistencies that you've identified within the standard industrial classification. If you could speak to those inconsistencies at a broad level. You needn't drill down into specifics, but if you could give us an understanding of what the broad general problems and inconsistencies are. And then allied to that, I understand your point that given the diversity within the medical devices sector, sub-targets would have to be set per division. But my question is, what sort of additional regulatory burden will this place on med tech companies? If you could give us some insight into that. Thank you.
Thank you very much. From my side, Tanya, is as you were making a presentation, and in what I would have expected, because we are addressing, we're talking about employment equity, and in that amendment, in that we are in the process of wanting to address inequalities in the entire country and sectors like yourselves. And therefore you did say that you are a long established a company with all these diverse systems or whatever. But I would have expected that, among other things, I must not read in between lines and assume that, among other things, that because of the nature of this industry, you'll have a challenge of race, you'll have a challenge of gender, you'll have a challenge of people with disabilities, you'll also have a challenge of age. I'm raising this because it is a sector that also touches into the system of education that, as this country we are coming from, which at a particular time never enable a certain grouping and community to be part of. Let me make an example. I've got a colleague, I'm coming from the health sector. I've got a colleague of mine whose daughter, when she applied, although it's not, when she applied that particular time to be a medical technologist at the time, before 1994, parents were asked to put it in writing why they want their child to do medical technology. and the student herself was asked to write that, so that he gets permission from the Minister of Health, of Education at that particular time. She's still here. She's still the parent and herself. She's a medical technologist now. I'm making that example to illustrate to you that one understands that this sector, it's one of those sectors that really, and I'm happy that you have got a chairperson of the transformation a committee, and it then means you are really committed. But in that in you being committed from my side, is that I would have appreciated if you would have been open and to be open to us to say, in fact, the other thing that makes us to be committed is because this sector, if I can just be blunt, is more white male dominated. In terms of age, it's this, because we are we are coming from this, and I think it's something that Tanya and Ms. Masilo, I would have then appreciated that you then be open to us, so that we don't, because among other things, those are the things, they may be seen as being petty, they may be seen as we are still stuck on the past, but no, as we are moving forward, wanted to correct a situation, which we must do, that there are some of those things when people say we have to take a fine comb. So my clarity for me, the question from you is this: didn't you see it necessary to reflect that to us, so that we are, when we deliberate at a particular time, we're then able to, as the committee, to reflect on some of those things. I think for me, those will just be questions. But lastly, just to say that I get a sense that you may have missed the initial process of the bill, in terms of the process that it is then the department, through the minister, that will request submissions from the public. We are not going to give you clarities now on some of the things that you are asking, because for us is to get clarity. The department is here. The department is then going to dot that, so that when then we deliberate, and will be advised by the legal fundis, how best do we address your clarity? But we're not going to now allow, because we're not at that stage. We're at the stage where we are listening at you and jotting down and asking questions of clarity. I will, in the absence of other hands, I will then give you the platform to respond, allow you to respond.
Okay, Chairperson, thank you for your questions. And I think you are absolutely correct. I agree with you that the sector has transformed at a snail pace, right? So there, I fully agree with you. And I think you're correct that we should have mentioned it when we started with this presentation. So probably it was an oversight from us, but it is something that we will take, that next time when we engage in such a forum, that we start first by acknowledging some of the things. And in terms of the transformation in the sector, I joined a summit as a board member and as a transformation chair committee about 2 years ago. And it is something that we are taking very seriously. We are aware that we need to really work very hard. And we now at least have a strategy, and we have some plans of how we're going to do it. I worked in the sector myself for the last 20 years, so I do know what you mean when you say that the sector is not transformed. So I want to say to you, Chair, you're absolutely correct, and I agree with you. So while I'm still on, I will take the opportunity to respond to the question that was asked by Honorable Ms. Mkonto. I think I'm pronouncing it correctly. So when I was referring to employers' own setting their own targets, I was talking about the current Employment Equity Act. So with the current Employment Equity Act, normally on an annual basis, the employer will say, this is how I'm going to transform, or these are my targets in the next 3 years. So the employer is currently, so this is what employers are currently doing now. They are submitting the Employment Equity Plan to the Department of Labor every 2 years, and they are saying, this is how we're going to transform. So this is something that is currently happening. So with regards to this bill, what we were suggesting is that when the minister sets their sectorial targets, it should be in consultation with the sector, so that the sector could say, these targets we will not be able to reach because of these reasons, or these targets are low, they are easily reached because of these reasons. How about the targets be, I don't know, in this range, because this is something that could be done. So that's what I was referring to. I hope I have clarified it. Thank you.
Thank you very much. Tanya, the Honorable Kado has also asked a question. Okay, I'll hand over to you now to respond.
Thank you, Honorable Chair. Just if I can also just add, if I may, to what Watse said, we have also in the last 2 years done a kind of transformation landscape analysis of our membership. So we know what the picture looks like, and we know now what we need to do to try and transform, and the committee is coming up with some very real, constructive, practical interventions to support that transformation, and we would be very willing to share that with you at another point if you would like us to do that. The question around the regulations and why they were mentioned and how they align or not. I think the example that we gave in our submission was every single medical device company has to have, for example, someone called an authorized representative by law. Now, if we start looking at, targets, and I think the complexity comes in when companies themselves within the medtech sector might fall within those different SIC areas. And so it becomes a little confusing then that if there are targets set within each of those sectors, yet, for example, an authorized representative is required across the entire medtech sector, how does one align with those targets? So that would just be a simple example. But I think to Motse's point, the other perhaps areas that might be misaligned would come out in discussion and through consultation. With regards to the targets and whether the subsectors align with the various types of companies. As I mentioned, even within a medtech company, for example, there might be importing or manufacturing a variety of medtech products. And so now they fall within a variety of those sectors within the SIC classification. So how does one then make sure that the targets that are set are realistic potentially, as Matse said, are either too high or maybe too low? So I hope that that has helped to answer that question. I think also something that we have realized is that there is a dearth of critical skills in our sector. And we really need to work at improving and drafting curriculum and creating learnerships so that people can learn those critical skills and grow the sector, but also grow the economy. And we are busy with an initiative right now looking at how we can support that. Another complexity in our sector, just something to mention, is that many of the medtech companies don't all fall under the same CETA. So depending on the types of products and the nature of the work that they do, they may fall under different CETAs. So that is just another area of complexity to consider. Thank you.
Okay, I think honorable members, in the absence, because I don't see any hands, I don't see anybody who's indicating. I think we have, thank you very much, Tanya and Motsi. My apologies if I'm pronouncing your surname wrongly. We will then, we will release. If you want to sit and listen to the others, it's fine. You're welcome. If you want to log out, it's still okay with us, but we're still continuing. Whenever, if you want to go and come back, it's okay with us. But thank you very much. Thank you very much.
Thank you, Chairperson.
Oh, welcome. Mr. Sakaza, who is the next?
Yes, Chair. The next one to present now, Chair, would be Agri Western Cape. I see Mr. Louis Vessels is made co-host, so he can share if he has got a screen to share. Louis Vessels from Agri Western Cape. Thank you, Chair.
Yeah, thank you, Chairperson, honourable members and guests. Thank you for the opportunity to present our oral representations to you today. My name is Louis Vessels, and I'm the Legal and Administrative Manager of Agri Western Cape. I am joined today by Mr. Yanni Stradon, who will assist in answering any questions you would pose to us today, and he is the Chief Executive Officer of Agri Western Cape. I would like, there he is on the screen, just getting you, Chair. I would like to take the opportunity to just give you a background of who and what Agri Western Cape is. We are an unbiased, apolitical federal organization. It is presenting primary producers, agricultural producers in the Western Cape. We are also a voluntary member-based organization. Our mandate of operation are within the region of the Western Cape, and currently we represent approximately 3,500 agricultural producers. Agri Western Cape promotes a healthy local agricultural and food supply. We do this within a province that has an extreme varied agricultural sector, going from extensive livestock farming in a currently drought-stricken areas like the Karoo to fruit farming, which is quite an intensive industry. Agri Western Cape at this moment, just to give further background, the farming industry is facing a situation where policy uncertainty reigns, and also facing input costs that's higher than inflation. Lastly, as background, I would like to state that Agri Western Cape supports successful and sustainable transformation within the sector. Chair, if we can move to specific comments that we have on the Act, as others that presented before us, we also submitted written presentations, and like I said, we welcome the opportunity to give clarification via our oral presentations today. Clause 4 of the amendment bill suggests the insertion of section 15 capital A into the Act, and in short, section 15A affords the Minister the authority to prescribe criteria and identify national economic sectors and subsectors for the purpose of ensuring the equitable representation of suitably qualified persons within that occupational levels. As I said, our comments will be to the Western Cape, and within the Western Cape, our demographic representation in rural areas are different to that of other other provinces, as theirs would also differ from ours and then other provinces. Numerical targets could make it impossible for producers in the farming sector and agri-processing sector to ensure the equitable representation of suitably qualified persons from designated groups, as may be prescribed by the targets. As I mentioned, we have an extremely varied landscape, and then with that demographic representation within the Western Cape. At the moment, section 15A gives a broad authority to the Minister to identify the subsectors and sectors for the transformational numeric targets, and no guidelines is currently provided to guide us as a sector as to how these sectors and guidelines would be proposed. We are concerned that at the moment, without the necessary insight into each sector and the demographic area within which the sector operates, that targets may be set which may be, as I mentioned, impossible to obtain, but also which may infringe on the rights of the population within that sector and demographic area to obtain work. Chair, if we move to clause 8 of the amendment bill, it suggests that section 27(4) that the National Minimum Wage Commission must research and investigate norms and benchmarks for appropriate income differential and advise the Minister on appropriate measures for reducing disproportionate differentials. Chair, Agri Western Cape wholeheartedly supports a wage in accordance with the Constitution to provide and to uphold each person with their human dignity. We are concerned to our interpretation of section 24 of 27(4) specifically, that this mandate goes beyond that of a constitutional and humanly dignified wage, in that it compensates, in that it tries, or in that it could try to rectify or not rectify, to put targets, numerical targets or compensational ratios between occupational levels within a sector and within the agricultural sector. If we move to clause 10 of the amendment bill, section 37, although this might seem like a small point to ask clarification on, the section or the part of the section that we are concerned with is that it states that the labour inspector may assign a person to serve the compliance order on behalf of the labour inspectors. I realise that also to the previous speaker, you mentioned that this is not the forum where you will be able to give us all the answers we are asking for clarification on or raising concerns on. But on this specific point, we would like to know in what circumstances would it be necessary for a labour inspector to assign a necessary person. The reason being twofold is, first, if the labour inspector serves a notice of non-compliance himself upon an employer, that gives the employer the opportunity to engage with the labour inspector on points of clarification as to where rectification needs to be made. Also, I'm sure you would have noticed that rural safety is a great concern throughout the whole country, and we would submit that if such a person is assigned by the labour inspector, there should be regulations as to how he or she should identify themselves when they enter the employer's premises, and that's purely for safety reasons. Chair, the last section I want to raise is clause 12 within the amendment bill, which suggests the amendment of section 53, and we purely raise this point because we raised our concerns earlier about section 15A, and section 53 states that a certificate of compliance can only be issued if section 15A is complied with. I'm not going to revisit our comments on section 15A. Chair, in short, that is our comments seen through the lens of primary agriculture within the region of the Western Cape. If there is any questions of clarification, we would gladly try to answer as far as possible.
Thank you very much, Mr. Stradon. Can I just check from Mr. Sakaza? Is the legal person around? Has she joined us? Mr. Sakaza? Mr. Sakaza?
Chair Suen Isaac is here. She should be able to.
Okay. No. The reason that I'm asking,
Yes.
I just want a guidance to end, because this thing, it keeps on coming, and I don't want us to be compromised. That in terms of clarities that are being sorted out by the presenters, those clarities, we won't be able to respond to them now, because the clarities that then the department will have to respond to at a particular time when we are deliberating. Can I just get guidance from you? Is the office of the chair correct? Is she, where
I
is
see she was here. I think she must have logged out. I will send her a message, Chair, to say
Can
that.
you please send her a message so that by the time we finish, she is then able to, because that's the purpose that she is to be here, is that they are to guide us. Okay, honorable members, there is the short and straight to the point presentation from Mr. Wessels. Any clarities? Over to you, Honorable Ngobo, and good morning, sir.
Thank you very much, Honorable Chairperson. A very little one. It's just that I did not hear. It's not even clarity. When the legal advisor, I forget the name, was making his presentation, I missed the number of the workers is representing. He said 8,500 or 800. 500. I just want to get that. To me, it's very important.
Thank you, Honorable Ngobo. Honorable Mkondo.
Chair, yes, Chair. We welcome the presentation from Agri Western Cape. Chair, my first question will be, whom are they representing? Are they representing work employees or employers, or are they representing both? And then the second question is, in the presentation, he said targets will be impossible, numerical targets will be impossible to achieve. I just want to know as to, is there any feasibility study that they have done? And if there is, can we be given details as to on what basis are the numerical targets very impossible to be achieved? Is it based on a shortage of qualified persons, shortage of skills, or any other reason? Thanks, Chair.
Thank you very much, Honorable Mkondo. Those were the two hands, Mr. Wessels. I will allow you to respond.
Thank you, Chair, and thank you for the questions. Question number one, I can just state that the number was 3,500. Was the number approximately 3,500? And then to the question two, who do we represent? So Agri Western Cape represents commercial agricultural producers throughout the Western Cape. So that's commercial farmers throughout the Western Cape. That is who we represent. And to the third question is with regards to the numerical targets, which was stated that it would be impossible to obtain or achieve. Just a point of clarification, and maybe I wasn't coming over quite correctly. I stated that we are concerned that that regarding what the targets would be, it might be impossible to achieve. So there's no feasibility study I can refer to at the moment, and that is also to a certain extent due to we not knowing what the numerical targets will be, or what the criteria will be for setting these numerical targets. So I think if that information comes to light, it would also be easier to refer to a study, or if necessary, conduct a study, Chair, if that's sufficiently clarified.
The difficulty with me is for you to come to a, should I say, a conclusion that the target will be impossible to achieve when you have not done any research or whatever, so that you come to, so you have come to that. So that's I think that's the importance of the clarification, because it is fine. We will then as we move forward, we'll see how best, when we are then being advised by the legal people. In the absence of, I don't know, Mr. Ngobo, or Honorable Ngobo, is it the old hand, or you still want to ask any other question? Or I'll assume it's the old hand. Thank you very much. In the absence of any other hands, thank you very much, Mr. Wessels. You are invited to be part to stay with us, or you can leave if you want to. Thank you very much.
Thank you, Chair.
Mr. Sakaza, who is the next?
Chair, now is the last one, which is the Banking Association of South Africa, the AgriSA. Ayanda he has been given the rights to can share the presentation. Ayanda.
Thank you.
Thank you very much. Thank you very much, ma'am. Can Mr. Ngobo lower his hand? Mr. Sakaza, please, can you request Mr. Ngobo to do that? Morning, Miss Ayanda. We'll hand over to you. Would like to see your face, ma'am.
Oh, you can't see my face, Honorable Chair?
Now, it's only now that I can see you.
Thank you. Honorable Chair and members, BASA would firstly like to thank you for extending this opportunity to allow us to present to you this morning. I am Ayanda Bayepi from the Banking Association, and I'll introduce to you who will be assisting with the presentation this morning. I have Mr. Bongane Sibanyoni.
Good morning, Chair. Good morning, honorable members.
Mrs. Nicolette Dussart. Hopefully she will be able to show us her face, Honorable Chair, but also I have Mr. Dungu Masindi.
Good morning, Chairperson. Good morning, honorable members.
Thank you, and Mr. Swiso Lukele. Sorry, Chair, I think he might not have been able to join us as yet, but these are the members that will be participating along myself this morning, and we trust that the presentation that we bring forth today will be of assistance to the committee to assist you to finalize the proposed amendments to this act, considering all the aspects and industries across the board. So firstly, Chair, I would just like to just state that, just open this, I hope you can all see it clearly. BASA is the industry association that is mandated to represent the banking sector on regulatory and other issues. And
sorry, ma'am.
Yes, ma'am.
I don't see anything on my screen. I only see a blue picture.
Okay, let me, okay. Can you see it now, Honorable Chair?
Okay, yeah, now I see the introduction. All right.
Thank you so much, ma'am. If I may just start then, I was saying that BASA is an industry association that is mandated to represent the banking sector on regulatory and other issues. And we'd like to state that BASA supports the tenor of the bill, which is aimed at addressing the slow pace of transformation within many South African workplaces. And I would just like to also state at this point that BASA acknowledges that there's a long way to be done in terms of transformation, you know, also along with other various sectors that are affected. But I think also we can also acknowledge the great strides that have been taken to ensure that there's transformation within the banking sector. Just to highlight, we have sent our submission to the committee, but there was just two specific issues that we wanted to just highlight as BASA. And one of those was firstly the consultation process. And what we just want to speak on in that respect is that in respect of section 1A, where there's a proposed deletion in paragraph B in the definition of designated employer. BASA is of the view that the deletion has the unintended consequence of exempting small businesses from application of affirmative action, regardless of their annual turnover. And we are of the view that this has a potential of creating a loophole for employers who employ 50 or more employees to to restructure in a manner that excludes them from the application of affirmative action, regardless of their annual turnover. So that's just what we wanted to bring in that respect. And also the proposed amendment in terms of section 15A, I think for us, we note that section 15A(3) gives all the powers to the minister to set targets in consultation with the National Minimum Wage Commission and not the relevant sector. And we are of the view that this could be problematic in the sense that it would fundamentally alter the agreements that were made at NEDLAC by business as well as the social partners. And what BASA proposes is that the minister should revert to the initial agreements which were made, that were negotiated at NEDLAC, that is to consult with the relevant sector bodies when setting the sector standards. And I think one of the concerns that we might also have is that in respect of, consulting the commission, is that the commission might not be fully versed about all the various issues that may be, be faced by each different sector. And I think just on this point, Honorable Chair, I would just like to bring in my colleague, Mr. Bongani Sibanyoni, just to elaborate on this point that BASA would like to make. Thank you.
Thank you, Honorable Chair. I think Ayanda has, highlighted some of the concerns that we have in relation to the consultation process. But I think the assurance that we also want to give the committee is that we are fully in support of the sector targets. So that just as a starting point, what we are saying as a banking sector is we would appreciate being given the opportunity, Chair, when the minister sets the targets, to consult with the specific sector in order to be able to understand the nuances that might particularly exist in that sector, so that when we set the targets for that sector, we don't set them for the sake of setting targets, but we set realistic targets that are achievable by the sector as agreed with the minister. We note the involvement of the commission and our concern in terms of that. We certainly believe the commission should be involved. However, the stakeholders that sit within the commission would not necessarily have a specific knowledge in a particular sector to understand what are some of the barriers, what are some of the things that we can look at removing as barriers to be able to set targets that are realistic for the particular sector. Additionally, to make sure that when we hold each other to account, we are holding each other to account on something that we all agreed on between us as well as the minister. That's the one point we really wanted to emphasize, Chair, to say we are fully in support. We understand that not everyone might be in the same page as us, but the banking sector, we believe that there's a lot of work that was done through NEDLAC between the social partners, and we certainly want to do whatever we can on our side to make sure that we move forward together with government in making sure that employment equity and affirmative action in particular are fully implemented as agreed by the social partners. That will be all for me for now, Chair, just in emphasizing the point that Ayanda raised.
Thank you so much, Bongani. If we may continue, Chair. So that is just one of the points that we wanted to bring in respect of the consultation process. And also just to note that in respect of section 4A, where it speaks about the targets that need to be set for different occupational levels, subsectors or regions within a sector on the basis of any other relevant factor. The point I wanted to just bring across in this point was that ideally that the sector targets should be set nationally and not differentiated by region, as a business with a national footprint would need to comply with different targets by region, and this would place a burden in terms of restructuring, planning, and managing the compliance requirements for those businesses that operate nationally. And just another point that in respect of one of the fundamental principles which are part of the Employment Equity Act, that is Section 15.3, is that quotas should be excluded when affirmative measures are designed. Essentially, imposed regional targets, simply put, are quotas, and these quotas will be imposed on a particular industry, and companies would be expected to achieve those targets. And the companies have different challenges and are moving from a different basis, and irrespective of being in a similar sector or industry. And I think what we would just like to just state was that overall, we are of the view that the process to set targets should be consultative, fair, and also transparent. And the second point that we wanted to raise, Honorable Chair, is just in respect of conflating of CCMA and employment equity processes. And what we mean by this, so in respect of the proposed amendment in terms of Section 53, where it states that the minister may only issue a certificate, meaning a compliance certificate in terms of subsection 2, if the minister is satisfied that. So the point we wanted to raise here, Honorable Chair, was that employee disputes are unavoidable, and the outcomes of legal proceedings are often unpredictable as well. So as such, we are of the view that to place reliance of outcomes of CCMA or labor court decisions to determine whether an employee can be issued with a compliant, an employer can be issued with a compliance certificate goes against the spirit of fairness. And further, the CCMA and court processes should not be combined with a legislative process. Otherwise, then we run the risk of employers being afraid to discipline employees for the fear of not being able to obtain a compliance certificate, as court proceedings can be unpredictable at times. And the CCMA and labor courts are there to protect employees and employers, to enable them to settle their disputes between them, and therefore the outcome of such processes should not be used against employers. So we as BASA would propose that this requirement be removed from the employment equity compliance. I would just like to ask if Mr. Masindi would at this point like to just come in, Chair, just to re-emphasize the point that we are just trying to make to the Honorable Committee. Thank you.
Thank you, Ayanda. Yeah, so this is something that we feel strongly about, honorable members and honorable chairperson, that should not be conflated. I think it will make it really difficult for planning purposes if you know that there are cases, as it is always the case, pending, to plan appropriately in order to achieve the targets that would have been set for the sector. I think the burden of dealing with two separate processes would be unreasonable for any employer, and as such, we would propose and recommend that the two processes are not conflated. Thank you very much.
Thank you, Mr. Yes, Honorable Chair.
I wanted to check if you are done or you're still continuing.
We are done, Honorable Chair. We just want to thank you for giving us the opportunity, and we are free to take any questions that may come from the floor. Thank you so much, Chair.
Thank you, honorable members. There is the presentation from the Banking Association of South Africa. Am I correct? Yes. Any questions of clarity? Honorable Ricardo, Honorable Mkonto.
Thank you, Chair. At one point in the presentation, on one of the slides, you said that imposed regional targets are quotas. And I just wanted you to clarify and unpack that statement. Why do you single out regional targets as, in effect, amounting to quotas? I mean, one should equally be able to say, surely, that imposed national targets are quotas. Any imposed target is a quota, in my view. So if you could unpack your reasoning behind why you specifically mention the imposition of regional targets as quotas, I would be grateful. Thank you.
Kondo?
Thanks, Chair. My first question will be on the section 15A that the presenters referred to. That one of they referred to the network agreements. I just want to check with them if, according to their observation, those agreements were able to achieve the aspired goals or results. Not with them only, but with other sectors. That's according to their observation, Chair. And then the second and last one is they are saying the CCMA and the Labour Court is protecting employers. Don't they think that we need something proactive? Because the two that they are referring to, they are reactive. So is it not time, according to them, that we need a legislation that will be proactive in protecting employees? Thanks, Chair.
Thank you very much. Just a clarity from myself. When a process of this nature, which is trying to address a challenge of the country and sectors of this nature are one of those that had a serious challenge. Why, if you can clarify to me, why referring to that, if those are to be corrected, you refer to them as quotas? I'm not going to, I think on what Honorable Kado said, why do you say regional instead of national? But for me, it's about why refer to that as quotas. And yeah, if you can just clarify for me. Thank you. Before that, can I check Ms. Isaacs, our legal person, was said is going to join us in the next 15 minutes. Before you respond, there is somebody by Mr. Sakaza who's 8234824. Who is that person? Who is that person? A23482. Can you just check that person? Or can that person indicate to us now who is he or she, so that we know? Because everybody here has got a name. Who's A23484?
I'm also not sure, Chair. I also saw that number.
Can that person please clarify to us her or his name? All right. Can you, Ms. Ayanda and your team, respond?
Thank you, Honorable Chair. Sorry, I was just trying to find the unmute button. So if we may just start with the questions for the CCMA regarding the protection of employees, and that the CCMA and the Labour Court are perhaps reactive in protecting employees. I would just like to ask Mr. Ndunga to just take that question. Thank you, Honorable Chair.
Thank you, Ayanda. And thank you, Honorable Control. We appreciate the question. We just feel that if we were to rely on cases that may be pending, in some cases, let's give an example. If an employer was to be issued with a certificate of compliance now, because they have no cases, and 2 weeks down the line, there is a big case which they lose. It's also not clear if that will be applied retrospectively. So if this was to be applied at all, then I don't see how it would work, because there are just so many cases that an employer will deal with at any given point, particularly the CCMA cases, more so or less than the Labour Court cases. How would that work if those cases are taking much longer, and I mean, the provision that has been made here is within the period of 3 years, so which is also quite long, because it might be that some of the cases are being appealed, and in the end, the employer might win those cases. So I think we should have confidence in the CCMA cases and the Labour Court cases, and we separate the issue of compliance with employment from that, and where the employer is on the wrong, the CCMA or the Labour Court are able to act and issue punitive measures against that particular employer. And would appreciate that we do not introduce unnecessary complexity in terms of that. Thank you very much.
Yes, any other, is there any person who wants to respond from your side?
No other comments, Chair, unless we need to further clarify and answer is not clear to you. Thanks. So I think just to then answer the question that was raised just in respect of the targets, please can I ask Nicolette, I'm not sure, she advised that her mic was not working, or Bongane, if they can assist with that question. Thank you.
Thank you, Chair. I'll take the specific questions related to the issues of the quotas. So I think in our presentation we try to illustrate, we put it in inverted commas, that you know, when we reference quotas per se, you know, we understand the historical context of the use of that word in relation to matters that are related to employment equity, where what we're trying to highlight is, if you introduce you know, a selection criteria that is based on a regional basis, and we call it targets by it's you know, it's by its very name to us, on the basis that it's, you know, based on, this is the, if you look at a specific region, there's these types of various populations that is in that particular region, and and so many of them should be in these particular positions and so forth. We believe that we might fall into the trap of us going back to debating issues that are related to quotas, whilst this is not what we are trying to do with the Employment Equity Act. We are actually trying to set and achieve national targets of affirmative action in industries, to your point, Chair, like ours, where we have been singled out for many years as lacking in terms of our pace in as far as transformation is concerned. And we really do not want the debate to bog down, as Honorable Member mentioned, that, you know, why are we now calling the national part quota? I mean, why are we saying regionals are quotas, but national is not quotas? We, based on the historical issues related to quotas and debates on regional selections previously, we are just afraid that if we go back to that particular type of selection criteria, we are going to get bogged down into debates about quotas again. We certainly, Chair, in terms of your specific question, in terms of why is the banking industry calling affirmative action quotas, we are perhaps we didn't choose the right words and we didn't articulate the point that we're trying to put across, to say, let us not get ourselves in a situation where we are going to debate and start arguing about the issue of quotas while we are trying to set national sectoral targets, working together, hopefully with the sectors, in order to set those particular targets in order to achieve employment equity, Chair. So we are by no means saying that we are dealing with quotas here, but we are, out of an abundance of caution, believe that you know, we do not want to get into a position where we are derailed in terms of trying to achieve what we want to achieve as a country, in terms of what this legislation is trying to achieve by arguing about the issue of quotas. So that is the point that we are trying to raise, Chair. You can rest assured, I think that the banking industry is certainly not saying that the bill as proposed is one where, you know, we are being taken back to what we might call quotas as various industries. We are saying that might be the impression that comes across, and the debate might then focus on that if we look at the regional side of things based on historical issues that we faced in that respect. So that is the response to that, Chair. And I think I will take the other question as well in relation to the NEDLAC circumstances and the previous agreements that the social partners have agreed to within the NEDLAC framework, and whether those agreements have enabled us to achieve what we are trying to achieve from a transformation perspective. Chair, I do believe that there has been traction. It is quite slow, to be honest. And I think, Chair, the reason that most of the NEDLAC social partners, in terms of this particular bill, were very happy to support the bill, it was really on the basis of that we all recognize, at least within the NEDLAC structure, that we are far behind in terms of where we wanted to be, and we cannot look at this bill and view it and think that there's doomsday that's coming because of this bill. We have to find a way to accelerate the pace of transformation in the country. And we are happy to work with, as social partners, work with government, in particular in relation to this bill, to find a way forward that will accelerate. However, we then, within that context at NEDLAC, said, because we represent various sectors within the NEDLAC business space, there are various sectors who are facing various different challenges. And they're at various stages of their transformation journeys. It will be beneficial for the minister when setting targets for a particular sector to then be steeped in the understanding of that sector by consulting with the sector to understand the historical challenges that have been faced, to understand the future potential challenges, and then with that particular sector come to an agreement, which ultimately it will be the minister's responsibility to say, well, this is having taken into cognizance the consultation process that we've undertaken, having taken into cognizance the information that you've provided me, those are the targets that I believe will be appropriate for this particular sector, and we can work from that basis. So the consultation chair for us is really critical. So we fully appreciate the slow pace of the achievements that we wanted to achieve from a transformation perspective. Hence, we are fully in support from a NEDLAC perspective now going forward of the bill on the basis of the consultation process that we had agreed with the various social partners and the minister. This is how we can approach it going forward. So that's to just say, Chair, we recognize that agreements have been made in the past. Perhaps they have not been appropriately implemented in the first phase that we need them to be implemented by. However, recognizing that very fact, I would say, happy for the legislation to then allow the minister to set targets, sectoral targets. However, those must be done in proper consultative manner and transparent manner with the particular sector. That is all for me, Chair.
Thank you, Bongane. Chair, if you may just allow us, I would just also like to ask Mr. Lukele to just come in at this point. Thank you.
Thank you very much.
So A2348424, it's you, Mr. Lukele.
It is. I'm
Yes,
sorry, Chair.
When I have been saying, who is this person? Can that person introduce himself? I should have taken you out and I was going to be seen and you were going to go to court and complain that you were taken out on the... Please don't do that again. If you are requested to introduce yourself, please do that.
My apologies, Chair.
Okay.
I didn't get that when you were asking. My humble apologies, but thank you for allowing me in. I think the issue of quotas, Chair, we as a team, looking back at where the country comes from in relation to transformation, always look at the country as a total population. The issue of regionalizing the country and trying to almost subdivide it is probably also a product of our past. People are moving around now. This regionalization of people in an entire country is actually almost going against the grain of transforming an entire country. And so when we humbly submitted, our view was that whilst people have historically lived in particular regions, we are one country. Transformation must be viewed in that light so that we all understand that we want to empower local people, but at the end, the target is a transformed South Africa. And that is the basis really that has brought us to this house to suggest that regionalization or regional targeting almost transforms us back to a quota system. We didn't want, it wasn't as if we wanted to offend the house. The issue was just that when we do that, we lose the bigger goal, which is a transformation for South Africa Incorporated. I think that's what I needed to add, and maybe just a little bit to what Bongani was saying earlier on, as a colleague is on the money in terms of we cannot, as NEDLAC, be a part other than a part of South Africa. The pace that you see at NEDLAC is reflective of a country. We are desirous of ensuring that we transform and that we assist in the acceleration thereof. And we're still very committed to do that, but we acknowledge that different industries, due to skills and history, are not going to just take off like that. But we are encouraged by the transformation we are seeing in the majority of the members thereof. Thank you very, very much.
Thank you very much. I hope am I audible?
Yes, you are, Chair.
Yes, I'm audible. I don't know what I've touched here now. I can't go back to my things, and I hope the media people, I hope my face is being seen. I would have loved that, and it may be seen as a trivial point, and I'm consistent on this thing, on this point, that when we are dealing with employment equity, which entails a number of things, and among them it's demographics. And in you being committed in the transformation, which we are happy for, I think as an activist and as a public representative, I would have appreciated if you would have just take us through. You are here, you have been in this sector. We know the sector, where it is coming from, but how are things now, among other things, in terms of age, in terms of race, in terms of gender, and in terms of disability? Because we must have a full view when we are deliberating. We must have a full view so that we don't in our discussions be general. I think we have passed the stage of being general. It's 26 years that the people of this country are complaining that there is no transformation that they see. It depends sector by sector. And if a sector has taken a view and a decision to come in front of the committee, it is my feeling that at least expose us. I am not in the banking sector. Maybe my other colleagues may be aware. So that's why my comment and my question to you is, wouldn't you have seen it better to just give us that background? It is important when we are to correct a situation, an environment that this country has gone through. So you must also understand my clarity within that context. Any comment?
Chair, I think your comments are very fair and they are very valid. And I guess maybe in us preparing for this presentation was that time maybe was a factor on our side. But if the Honorable Chair would indulge us, and if you would want, in respect of putting you in a fuller picture, that we could do an additional submission to this committee. We do have the data that you are referring to. So in that respect, we would be more than happy to assist in giving you the fuller picture by providing perhaps a supplementary submission. Thank you, Chair.
Can I just check, Mr. Sakaza? Is the legal person around?
Yes, Chair, I see she's joined.
Yes, joined. Ms. Isaacs, the reason that I wanted you to welcoming you, the reason that I wanted you to come and join us, because among other things, your responsibility is also to guide us as we move forward. In the clarities that we are seeking now, companies, institutions are requesting to give us that as an additional information. But there are also two companies that have asked clarities, and my response was that we are not going to be able to give them clarities because those are more for the department. They will be clarified, those at the time when the department will be responding when we are deliberating. So I wanted to, whilst everybody's here, you to guide us so that we don't move out of this with a wrong assumption, and down the line we are then being challenged. So that's why I said you must be located, and can you then just come in and guide the office of the chair and the committee and the presenters as a legal person. Are you here?
Yes, Chair, I am here. Chairperson, I just want to clarify your question. Is the presenters have asked the committee for clarity on a particular matter, and the chairperson's response was that the department will answer that question when it's their turn to present. Yes, Chairperson, that is correct.
When, because now it's the committee that has received oral presentations, oral submissions. In terms of the department is here to listen and take notes. Now, if then a presenter wants a clarity, that's where I want myself to be clarified, so that I don't put the integrity of the committee at risk, because down the line we will then be challenged, and that we're never afforded an opportunity for clarity. I just want to put that, because I want difficult times, things that we address them now when everybody's here, so that I protect the integrity of the committee.
Yes, thank you, Chairperson, just for clarifying that. I think that is perfectly fine. It's not that the committee's, the person is not going to get a response, it's that they will get a response at the appropriate time, and that is when the department will be allowed to present. So it's merely for them to be aware as to when the next meeting with the department is. Then they will be able to, that question will be put to the department. I mean, the department is the custodian of the legislation, and they would be better placed to respond to specific queries regarding the bill that is currently deliberated on. Thank you, Chair.
Okay. No, so it then means we're still in order. The second one is that we have asked them questions of clarity. Let me be specific. I asked the other one, and Summit, I'm also asking Busa that we are correcting the bill. It's about to ensure that we address the issues of transformation. Will it not be correct for them to have just given us a background in terms of the demographics of their institution, gender, race, age, and disability? They then said they haven't done that because of time. They haven't put it in their presentation. But if we want it, they can then circulate it to us. Is that correct? Are we will still be in order if then we accede to that request.
Yes, thank you, Chairperson. Yes, there's nothing wrong with the committee requesting further information. The processing of a bill is a deliberation process. So if the committee wants further information to help it to make better decisions, that's perfectly fine, and that's within the committee's right to do so.
Okay. No, fine. Thank you very much. Honorable members, as I've said initially when we started this process, that we will have to clear issues as we move along, because I don't want us to muddy this process of the amendment of a bill. It's quite a stressful and a strenuous process, but if some of the areas we can just be able to clear them so that we don't continue with the work, and down the line we are then challenged, and people say when they don't get what they wanted, they say, yeah, that chairperson never gave us an opportunity. So Busa, you are here, Summit, you are here. The information that we requested in terms of the demographics, but again, I think the Secretariat is here, is taking note of what you are saying, because obviously deliberations, committees are a public thing. So even people, institutions who made presentations, it's also their responsibility to check the website of the committee, of the parliament, to see when the committee is going to sit and deliberate. So I'm also putting a responsibility onto them, that they have then got that responsibility of following a process as they have shown of wanting to come, and the interest of wanting to come and make oral presentations and clarify some of their areas. Thank you very much. Thank you very much, Suen, for that. Thank you very much, Busa.
Thank you, Chair.
Yeah, thank you very much. I see that it's young people. And yeah, okay, that's fine. Apologies accepted to the last, from the, we accept the apology that you have put the person who only put numbers in terms of instead of putting his name. I think that was the last presentation for today. Mr. Sakaza, am I correct?
Yes, Chair, that was the last for today.
Okay, my apologies. I don't know what is it that I just, oh, there I am. Oh yeah, sorry, very sorry. We are then, we are meeting tomorrow, again, same time. It is the last time for, the last day for the employment equity in relation to those companies and individuals that have reflected that they would like to come and make oral submissions. So we will meet again tomorrow at 9. And yeah, I think, and we'll ask Suen if please you can join us. I know you have got other commitments, but if you can join us tomorrow on time, I will appreciate that. Having said that, thank you very much, honorable members. Until we meet again tomorrow.
Thank you very much, Chairperson, and thank you very much to all the colleagues.
Thank you. Bye.
Bye.
Zolani, can we talk?
Thank you, Chair.
Thank you.
Okay, Chair, you can. You want me to call you, Chair?
Yes.
Now? Okay.
Yes.